Today, we're going to look at the major United Nations human rights treaties and the 4 Geneva Conventions. These events began to unfold after World War II and after the Universal Declaration of Human Rights was crafted. And as you'll see, 2 of the major treaties adopted by the United Nations and have been widely ratified by nations across the world really came pretty directly out of the Universal Declaration of Human Rights. And our objectives today are to learn about the provisions of the major UN treaties. We'll do that by your close reading of those treaties and through the lecture today. We want you to understand the role of the treaty bodies. Now, look at this language. Most of these human rights treaties also have a treaty body, that is, a group organized by the United Nations to assure compliance with the treaty. One of the major treaties, the Treaty on Genocide, does not have a treaty body, but for the other major treaties, we do have treaty bodies, and we'll want to understand how they function. We hope that in addition to human rights law, we'll have a look at humanitarian law, that is the Geneva Conventions, and what has come out of that work. As I've already said, the Universal Declaration for Human Rights really provided the framework, actually many times the language that's gone into other international treaties, not only the International Covenant for Civil and Political Rights, which we'll look at shortly, and the International Covenant for Economic, Social, and Cultural Rights, which will also be part of this lecture, but also a number of other treaties draw on, and many of them expand on the provisions of the Universal Declarations of Human Rights. Now, as we begin to look at UN treaties, the first UN treaty actually was adopted before, a day before, the Universal Declaration of Human Rights, and it was a treaty on the crime of genocide. There's one man we can look to as a person who not only invented the name genocide, but also did much of the work leading to its adoption of the treaty itself.
Genocide is a new word combining the Greek word genos, genos meaning race or group, with the root of the Latin sidere, meaning to kill. Dr. Raphael Lemkin, who is a professor of law at Yale University and specializing in teaching matters about the United Nations. Dr. Lemkin is the man who created the word genocide. Dr. Lemkin, could you give us a little background on how you came to be interested in this genocide?
I became interested in genocide because it happened so many times. It happened to the Armenians, and after the Armenians, Hitler took action.
Lemkin became the leading force behind the drafting and adoption of the International Convention on the Prevention and Punishment of the Crime of Genocide, adopted unanimously by the United Nations General Assembly in Paris on December 9, 1948.
I would urge, and I think that's the spirit, the unanimous view of the Assembly, that this convention be signed by all states, ratified by all parliaments at the earliest date, in order that basic human rights be given the protection of international law for the sake of progress, social and international peace.
Raphael Lemkin was a very interesting man. He was Jewish, quite prominent in Poland. When the Nazis invaded Poland on September 1st, 1939, he enlisted in the Polish army, was wounded defending Warsaw, later fled through Lithuania to Sweden, and from Sweden came to the United States. He had taught law back in Poland, and in the United States he taught at several American law schools. He wrote a book in which he put forward the concept of genocide, a word which he had invented. Raphael Lemkin spoke 14 languages, was an incredible scholar, and he invented the word genocide from a Greek word and a Latin word. and we had known of the acts, which we know is genocide, before Lemkin, but we never had a label. And international law did not have principles that were adopted against genocide until Raphael Lemkin. The General Assembly adopted the Genocide Treaty on December 9th, that is the day before the Universal Declaration of Human Rights. It received enough signatures and ratifications by 1951 to become part of international law. We say that it went into effect in 1951, but it was not until 1988 that the United States ratified. And this is another story about an important man. The person that we want to identify here is Senator William Proxmire from Wisconsin, a fascinating person who really believed that the United States had an obligation to ratify this treaty. William Proxmire gave a speech every day on the Senate floor until he had given more than 3,000 speeches. The speeches were all different too. This was not delivering the same speech day after day. He crafted a new speech to give each day on the Senate floor. And after many years, 1988, it was ratified. It was ratified because President Ronald Reagan felt like he should get behind the Genocide Treaty. Now, he never supported it before, but he made a trip to Germany, and he made the mistake of going to a German cemetery in Bitburg, Germany, and it was a cemetery that housed a large number of tombstones from SS troops from Nazi Germany. And there was an outrage that the President of the United States goes to this particular cemetery, lays a wreath, and says some words which he meant to be words, I think, of solidarity with Germany. But it turned out that this outrage came, and he needed to do something to repair his image. And the thing he did was to push for the adoption of the Genocide Treaty.
Senator Proxmire was and still is a political icon, beloved and esteemed by everyone who knew him, and leaves a powerful legacy of the persistence of one man and how he made a tremendous difference for our country and throughout the world. He was the beginning voice every morning when the Senate opened. Over 19 years and 3,200 speeches over and over again, that constant drumbeat.
I'm Senator William Proxmire of Wisconsin. The Genocide Convention, or treaty, is pending before the United States Senate. It's in the Foreign Relations Committee, and I feel that we should have passed this treaty long ago, and it's disgraceful that we haven't passed it yet. We can talk and hope and pray that it won't happen again, but if we want to act to prevent it happening again, the signing and the approving of the Genocide Convention is, in my judgment, the best way to do it.
Senator Proxmire was not going to take no for an answer, and to his great credit, and I think it was showed by the admiration of his colleagues that he stayed with it long enough until they finally saw the wisdom to be able to bring that up. And of course, when it did, it passed with wide bipartisan majority, and it restored our image in the international community. But it's a lesson that I learned early on, is the difference one person can still make in the course of events.
There are several things we ought to note about the Genocide Treaty. I've already mentioned one of them, and that is the fact that there's no treaty body. So the Genocide Treaty exists without a United Nations organization that's directly responsible for the treaty itself. There is a special official appointed by the UN to monitor genocide and the possibilities of genocide, and that official is the person who serves alone, does not have a committee or treaty body to whom he reports. We ought to also note that this treaty suggests that criminal laws be adopted. It even has a suggestion that there be an international criminal court to enforce genocide. We now have that court called the International Criminal Court, but that did not come into being until many, many years after the Genocide Treaty itself. And one feature of the Genocide Treaty is that there's an agreement that that all nations signing agreed to extradition where necessary. Now, one of the hard things that Lemkin and others had to do in fashioning the Genocide Treaty was to figure out, you now have got a word, what does it mean? What does it mean in law? What is genocide? And according to the provisions of the Genocide Treaty, it is any act committed with the idea of destroying in whole or part a national, ethnic, racial, or religious group. Now, note what's not in there. A political group is not in there. It is really directed towards religious, ethnic groups, racial groups, and we'll see instances in our more recent history where such acts have been committed, and the United Nations Security Council actually acts to form a court, a criminal court, to prosecute those who have been guilty of genocide. And as we'll see later in the course, that's happened in the former Yugoslavia and in Rwanda. And there is, as we've said earlier, now an international criminal court which also makes genocide a crime. The treaty itself mentions some special acts which would constitute genocide. Some of them will be very obvious to anybody with common sense. Killing members of the group, causing serious body harm or mental harm to the members of the group, deliberately inflicting conditions calculated to physically destroy the group, the whole group or even part of the group, forcefully transferring children of the group to another group. And these provisions were put into the treaty because there was experience of these things happening in Nazi Germany and other places. And so this, again, as with much of what we're talking about with the development of the Declaration of Human Rights and the treaties, much of it comes out of the experience of World War II. There's some other special features of the treaty. It says that there's no immunity from being prosecuted for committing genocide. Now that includes any ruler, the head of state, may not claim immunity. Genocide is a crime that is so horrible that even a head of state may not be exempt from prosecution. I now want to turn to humanitarian law. Note that we're jumping off the human rights track for just a second. But the reason I'd like to put the Red Cross and the Geneva Conventions in at this point is that these things occur about the same time. The Genocide Convention is put forward by the General Assembly in 1948, as is the Universal Declaration. And simultaneously with the work going on there, there's work going on that leads us to the Geneva Convention. We might start off in thinking about Geneva Convention by thinking about this remarkable organization, the International Committee of the Red Cross, that addresses humanitarian law issues. It was founded by Henry Dunant, who was a Swiss citizen who had published a book after seeing the horrors on the battlefield of Solferino in Italy, and he came across the battlefield. There were thousands of people who had been killed and thousands of people who were still on the battlefield without attention. So Mr. Dunant went to the battlefield, tried to provide help to the wounded, and out of that he founded the International Committee of the Red Cross. The International Committee of the Red Cross began its work pretty fast. In 1864, it adopted its first treaty. The famous nurse, Clara Barton, was very important in the United States effort to ratify that first treaty in 1882. In 1906, the Geneva Convention for the Amelioration of the Condition of the Wounded and Sick in Armies and at Sea was adopted. 1929, the Geneva Convention relative to the treatment of prisoners of war. And in World War II, the Geneva Convention was observed by many nations, including, for some prisoners, Germany recognized the Geneva Conventions and allowed the International Committee of the Red Cross to send delegations to prisoner of war camps, which is quite extraordinary. Now, prisoner of war camp, the Red Cross never got to some of the camps because the conditions there were quite horrible. But most camps that held primarily British and American prisoners, the Red Cross was able to inspect those camps. In 1949, there were conferences held in Geneva to reaffirm, expand, and update these three prior conventions, and added a new convention, the Geneva Convention relative to the protection of civilian persons at time of war. And what this came from was the observation that there was no treaty protecting civilians, but great numbers of civilians were killed in just about all the combatant nations, much of it through air bombardment, artillery fire that was not properly directed to military targets. And so this edition is extremely important. And so we now have these four conventions relating to soldiers, to military personnel at sea, to prisoners of war, and to civilians. We have three protocols, two of them important. One relates to the protection of victims of international armed conflicts, and number two relating to the protection of victims of non-international armed conflicts. The third protocol really adds another symbol so that you now have not only the Red Cross, but the Red Crescent. Of particular interest to us in this course will be Common Article 3. We have 4 Geneva Conventions, but all 4 of those conventions have the same language, identical language, in Article 3. So Article 3 requires humane treatment for all persons in enemy hands without any adverse distinction. It requires that the wounded, sick, and shipwrecked be collected and cared for. It says that the Red Cross has the right to offer its services of inspection and compliance. And it calls on all the parties to bring all parts of the Geneva Conventions into force through special agreements. Again, we'll look at Common Article 3 because if you read the specific language of Common Article 3, you'll see that it now suggests that the Geneva Conventions protect people who are no longer taking an active part in hostilities, and says that they shall be treated humanely. And it says that certain acts are prohibited: cruel treatment and torture, outrages upon personal dignity, in particular humiliating and degrading treatment. As we get to the part of the course where we are looking at the activities of the United States and other nations following the attacks on 9/11, we're going to find that some of those acts are hard to square with the language of Common Article 3. And we'll have a chance later in the course to look at the memoranda that were written by the Department of Justice and by Department of Defense lawyers and by White House counsel, by the Attorney General's office, and we'll see that they pay no attention to Common Article 3. And the reason we wanted to put out Common Article 3 now is it will turn out to be historically one of the more important provisions of international humanitarian law. I'd now like to talk about the UN treaty process. Again, we've already seen how the Geneva Convention, how the Genocide Treaty was formulated. We've seen how the Geneva Conventions were put together. We now have this process of looking at taking all these statements, all these principles laid out in the Universal Declaration of Human Rights and turning them into treaties. Now, from the very beginning, there were two major points of view concerning these treaties, the proposed treaties. Number one, the Soviet bloc countries believed that the rights that were most important were the economic, social, and cultural rights. And so the Soviet bloc countries favored the right to a job, the right to have good working conditions, those kinds of provisions. You look at their constitutions at this period, and those were already reflected in the constitutions of those Soviet bloc countries that had constitutions. They were very heavy on working conditions. And the second point of view held by most of the Western nations, and particularly strongly held by the United States and Great Britain, was that the political rights, the right to free speech, the right to assembly, the right to vote, those rights were the important rights. And now, as we begin to look at these two treaties, both adopted by the General Assembly in 1966, we're going to look at the first one, which now is the one that implements the principles being advocated by the United States and the United Kingdom. The International Convention on Civil and Political Rights has a number of provisions. It's important that you read through these treaties in detail so that you come to understand them. And what I will give you is nothing more than a very rough outline of the things you'll see when you read through article by article. Article 3 has a non-discrimination principle. And when you see something like that, think back on the words of Hermann Göring. Remember, he rejected the idea that all people are created equal. He rejected the idea of equality and said that that was not to be a principle recognized in Nazi Germany. Article 6 references the individual's inherent right to life. Now, it does not in itself abolish capital punishment. We'll see later provisions that accomplish that. Article 7 prohibits torture and cruel, inhumane, or degrading treatment. And when you see something like that, look at the overlay between the treaties and the Geneva Conventions, where in both of these you see the concept of humanity. You don't treat people in a way that's inhumane, and that concept goes into both human rights law and into humanitarian law. Article 8 prohibits slavery and enforced servitude. 9 prohibits arbitrary arrest and detention. There are procedural safeguards included in Article 9. Article 10 requires that anyone who is deprived of liberty be treated with dignity and humanity. We might ask ourselves, in the United States, do we adhere to Article 10 of the International Convention on Civil and Political Rights? Do we treat our prisoners with dignity and humanity? Article 12 guarantees freedom of movement. 13 prohibits the arbitrary expulsion of resident aliens and requires those decisions be reviewed by a court. Article 14 protects the right to justice and a fair trial. Article 15 prohibits prosecutions. 16 requires states to recognize everyone as a person before the law. And again, think back on the Nazi Germany history. Remember that early on in the Nuremberg laws and in the laws adopted before the 1935 Nuremberg law, there were rights of citizenship taken away from German citizens who were Jewish. Article 17 introduces the right of privacy, 18, freedom of religion, 19, freedom of expression, 20, mandates sanctions against incited hatred. Let's pause on this one for a second. As we look at the court decisions under the First Amendment of the United States Constitution, you'll see that the U.S. courts have been really pretty strict in saying that there would be no barrier to free speech. In the international regime, and we'll see later in the European regime, the idea that speech that incites people to hate others is prohibited. And so this is a curb on certain types of free speech. So some types of free speech that would be permitted in the United States would not be permitted in other countries. Articles 20 and 21 mandate freedom of association. Article 23, right of marriage. 24, right to a nationality. Again, think back on the German experience. Jews had their nationality taken away from them. Remember that at one point under the Nuremberg laws of 1935, Jewish citizens were not allowed to fly the German flag. They were allowed to fly a flag which identified them as Jewish, but were not allowed to fly a German flag. They essentially had some aspects of the nationality taken away from them. 26, again, has a broad principle of equality. And Article 27 talks about the right of people to have the benefit of their own culture. There are two optional protocols, which both of them have been widely adopted. First optional protocol establishes an individual complaints mechanism, and at some point we'll want to look at that a little bit more closely. The treaty body that the UN designates for enforcement of the International Convention on Civil and Political Rights is called the Human Rights Committee. Now be careful of this language. As you begin to look at UN bodies, you'll find there's a Human Rights Committee and a Human Rights Council. The Human Rights Committee has a very specific task, and that is to assure compliance with the International Convention on Civil and Political Rights. And there's a right to complain to that. And in the presentations that you'll make to the class, some of you will talk about the activities of the Human Rights Committee, what kinds of complaints and what kinds of results have been achieved through those complaints. And the second optional protocol abolishes the death penalty, allowing the use of the death penalty for serious military crimes at time of war. So those two protocols have been widely adopted. Now, the United States ratified the International Convention on Civil and Political Rights, but look at the way that the ratification takes place. It comes with three things that a number of nations do when they ratify conventions. There are reservations, understandings, and declarations. So if you want to look through the list of nations and see which nations have ratified, don't stop there. Look and see what the ratification says. Is there a ratification without any kind of reservation, without any kind of stated understanding, without a declaration? That clean ratification is not frequently done by the United States, and a number of other nations have reservations as well. I'm just pulling out one of the many reservations, understandings, and declarations by the United States to illustrate the kind of thing that can appear in these ratification documents. The United States understands that the covenant shall be implemented by the federal government. Let's pause there. There is in international law a principle that not all treaties are self-executing in all countries. So you adopt a treaty, you see the language in the treaty, and you say, gosh, that's now been ratified. And that must be now, in the United States, the supreme law of the land, because it now has been a treaty entered into by the United States Senate by 2/3 vote of the United States Senate, and so that must be the law in the United States. No, it's not. In many cases, it's not the law in the United States until a separate law is adopted. So you'll see in the list of American reservations, understandings, and declarations, you'll see there's a very explicit statement that that this treaty is not to be binding until adopted by law. Okay, now what's their undertaking as to whether it will adopt law? Well, the United States says that it will be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein. Okay, we're a federal system. The federal government does not have authority over all the items that are listed in the International Convention on Civil and Political Rights. And so the following words are that otherwise, by the state and local governments, to the extent that state and local governments exercise jurisdiction over such matters. And then the federal government pledges that it shall take measures appropriate to the federal system to ensure that that state and local governments also take up these measures and enact laws. If you begin to look at the principles laid out in the International Convention of Civil and Political Rights, and you look at this reservation, the United States makes this promise to the world when it ratifies. It never does it. It breaks its promise. There are not federal laws on all the provisions that are in the International Covenant on Civil and Political Rights, and there's been virtually nothing done to encourage states to comply with the convention. So look very seriously and very carefully when you see a nation ratifying and then pulling back through the process of issuing these reservations, understandings, and declarations. I now want to go to International Covenant on Economic, Social, and Cultural Rights. We will not spend as much time in this lecture talking about those because, as you'll see, these are rights that are not enforceable at any particular point in time. There is a UN process to monitor this treaty, and it's sort of interesting. It is the original third committee. It's the UN Committee on Economic and Social Rights that is established at the beginning of the United Nations. It was, remember, the umbrella committee that supervised the drafting on the Universal Declaration of Human Rights. And finally, when the International Covenant on Economic, Social, and Cultural Rights is adopted, you give back to this third committee the duty to look at the rights laid out So what kinds of rights? Labor rights, right to health, right to education, right to adequate standard of living. Those kinds of things are in this. Remember, at one point in an earlier lecture, we talked about first generation rights and second generation rights. If we were using that kind of terminology now, the first generation rights would be International Covenant on Civil and Political Rights, and second generation rights would be embodied in the International Convention on Economic, Social, and Cultural Rights. And look at the principle that's in this treaty. It's the principle of progressive realization. Unlike the principles laid out in the Convention on Civil and Political Rights, we now have the treaty telling us that each nation, each party to the treaty, shall take steps to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the Convention. And so we now have the idea incorporated that not all nations can afford to do all things that are embodied in this treaty. And even though they signed the treaty, they're not expected to achieve the result right away. But they pledge themselves to move down the path of trying to achieve the objectives. So now, what are the other? We've now really dealt with just detail with just two of the UN treaties plus Genocide Treaty. We also have the Convention Against Torture, a Convention on the Rights of Children, a convention which has been signed and ratified by all nations in the world except two, the United States and Somalia. There's a convention to end racial discrimination and a convention to end all forms of discrimination against women. Each of these conventions, except for genocide, have a treaty body. And as we've said, the International Convention on Civil and Political Rights has the Human Rights Committee, and the International Convention on Economic, Social, and Cultural Rights has a third committee monitoring the implementation of those treaties.